The silence inside a courtroom is not like the silence of any other place. It's a heavy silence loaded with history, with sentences and destinies that have been sealed between those four dark wooden walls. But today, for the man sitting in the leather chair, the silence wasn't out of respect, it was out of shock. The man who spent exactly 2 decades deciding the fate of others now holds a document that has the power to reduce his entire career to ash. His signature is there, at the bottom of the page, on the exact line, authenticated, stamped, with unquestionable legal validity. But there's a terrifying problem. He doesn't remember signing that paper. The notary seal is real, the ink is real, but the will behind that signature never existed. At least, not in the way the system believes. 20 years analyzing evidence, weighing truths and lies. Now, he finds himself in a situation he never imagined. He cannot prove that his own signature is, in fact, a lie. The room remains silent, but now it's a different silence. It's the sound of a reputation crumbling. Because for the first time in 20 years, the magistrate everyone knew for his rigor and unshakable ethics has become the defendant. His name, in the legal world, was synonymous with one word: rigor. He judged more than 2,000 cases, maybe more. He wasn't a man of improvisation. He didn't trust instincts or superficial appearances. For him, the world was made of facts, evidence, and documentary proof. Every piece of a case was tested under his magnifying glass. Every testimony was questioned until the last inconsistency appeared. The most experienced lawyers felt a chill down their spine when they knew the case would fall into his hands. Defendants respected him, knowing there would be no room for games. He knew all the tricks of the legal underworld. He had seen everything: crude document forgeries, testimonies fabricated with theatrical precision, evidence planted by corrupt detectives. He always saw through the curtain. He always found the truth. His fellow magistrates used to say he possessed a sixth sense, an almost supernatural ability to detect a lie before it was even told. But he always disagreed. For him, there was nothing mystical about it. It was pure method. It was exhausting discipline. It was the accumulated experience of someone who had read millions of pages of cases and understood that human beings always leave a trail when they try to deceive. He didn't believe in invisible traps. In his worldview, if something was wrong, there would be a trace, and he was the best at finding those traces. His daily routine was a testament to this obsession. He arrived at the courthouse before everyone else, when the hallways were still dark. He reviewed each case 3 times. He made handwritten notes, highlighted contradictions, and prepared questions that were like logical traps. Nothing passed without deep scrutiny. During hearings, his presence alone changed the weight of the air. He didn't need to shout. He didn't need to intimidate. He just asked the right questions and waited. He knew that truth is impatient. If you give it enough silence, it ends up revealing itself on its own. For 20 years, this formula was infallible. He was never deceived by a street con artist or a corrupt billionaire. He was never manipulated by well-constructed narratives. He never, in 2 decades, signed a document without understanding every comma, every clause, and every legal implication. Until it happened. And the scariest part wasn't the mistake itself. It was the fact that he didn't realize he was being devoured by a machine he himself had helped build. It all started with something that seemed harmless. An invitation. It wasn't a quick enrichment proposal or a promise of miraculous profit. It was an exclusive investment program, formatted specifically for the highest level professionals: judges, prosecutors, appellate judges, and CEOs of major corporations. People who, by nature, understand structure, process, and legitimacy. The company behind the invitation wasn't a garage startup. It had an impeccable federal registration, international financial security certifications, It was audited by world-renowned external firms. The office where meetings took place was in the financial heart of the city, in a glass and steel skyscraper that exuded seriousness. Everything in that environment said, "This is the safest place in the world." The judge, faithful to his method, didn't enter the business on impulse or greed. He investigated. He applied the same rigor he used in his judgments. He spent 3 weeks analyzing the company's financial health. He personally verified records with the Federal Revenue Service. He spoke with 5 professional colleagues who had been investors for over a year and were extremely satisfied. He requested audit reports from the last 2 years. He analyzed the projections and saw they were conservative, realistic, and safe. Nothing there raised a warning sign. Everything was exemplary, everything was transparent, everything was regulated. The first official meeting lasted hours. There was no rush to close the contract. On the contrary, the company's technical consultants answered all his questions with surgical precision. They presented legal theses on capital protection and showed how the system was shielded against volatility. When the time came to sign, everything was done within the strictest legality. The contract was taken to a trusted notary office. There was authentication of the signature by authenticity. Qualified witnesses, whose names and identities were verified, signed along with him. The money was transferred via official banking channels with full traceability, receipts, and declaration of origin. In the first 6 months, the system worked like a Swiss watch. Financial returns arrived on the exact day. Monthly reports were works of accounting art. Detailed graphs, invoices, digital timestamps, and electronic signatures with international legal validity. He filed each of these documents. He organized them in physical and digital folders, categorized by date and importance. As he used to say, the document is the final proof. At that moment, he felt secure. The system was solid. He had done his homework. He had checked every gear. There was no way to fail. But in the 7th month, the clock stopped. At first, the delay seemed like something common in a bureaucratic system. The company sent formal communications explaining they were going through an update in banking security protocols. It was a logical explanation. Large companies faced technical problems. The judge, accustomed to dealing with the slowness of the judiciary, didn't immediately alarm himself. He requested additional clarifications and received, in less than 24 hours, a technical report signed by software engineers and auditors, justifying each day of delay. Everything seemed reasonable, until the phone rang. On the other end of the line was a fellow magistrate, a man the judge deeply respected for his sagacity. But that man's voice was different. It was trembling. He had tried to make a full withdrawal of his investment for a personal matter and discovered something that defied logic. The contract the colleague had in hand, with his signature and the notary seal, was not the same contract that was in the company's central file. The judge felt a chill running up his spine, but his rational mind immediately tried to find a technical explanation. It must be a system error, he thought. He hung up the phone and rushed to his own archive. He grabbed his original copy, the one he himself saw being stamped at the notary office. He began to read, sentence by sentence. Then he opened the digital file that the company had sent as a backup copy months ago. At first, they seemed identical, but when he reached the termination and guarantee clauses, his heart raced. The clauses had been subtly altered. The withdrawal period had jumped from 30 days to 5 years. Early withdrawal penalties had doubled in value. The Judicial discussion forum had been changed to an inaccessible international jurisdiction, but what left him paralyzed was the bottom of the page. The signature. It was his signature. Every stroke, every pen pressure, every letter inclination. It was identical. The notary seal, too. The date was the same. How was this possible? Contracts don't change by themselves inside locked folders. He went to the notary office the next day, still believing he would prove this was all just a bureaucratic error. But upon accessing the original record in the notary's database, the final blow was struck. The document that was officially registered in the government system was the company's altered document, not his. The notary, a man who had known the judge for years, then explained what would be the masterstroke of this invisible fraud, something that traditional law was not yet ready to deal with. When you authenticate a document by similarity, or even by physical authenticity, the notary often validates only the signature itself. In a highly sophisticated technical scheme, the company used what experts call a metadata substitution attack. They didn't forge his signature. They used the real signature from a document, and through a process of digital manipulation and physical document chemistry, transferred that signature to a new version of the contract after the initial validation. They created a temporal vacuum. They used the state's legal structure, the notary office and public faith to validate a lie. Technically, for the system, the document was original. The protocols had been followed. The signatures were authentic. 20 years of career, thousands of frauds uncovered. And he didn't know that the system he protected so much had such a dark back door. The company didn't just have scammers. They had a legal department composed of brilliant minds who didn't want to violate the law. They wanted to use the law to make it their greatest weapon. They didn't create fake papers. They created legally valid versions of real documents. At that moment, the judge realized the size of the abyss. Proving fraud would be almost impossible, because for law, what matters is what is registered, and the record said he had agreed to everything. The investigation began, but not in the way he expected. Because he was an authority, the case wasn't treated just as a scam. He began to be seen as a potential accomplice. How did a judge with 20 years of experience not notice this? Investigators asked. Doubt began to corrode his reputation. The press, always eager for a monumental fall, showed no mercy. The headlines didn't say he was a victim. They said, elite magistrate involved in financial pyramid scheme. The legal world is driven by credibility, and his, built brick by brick over 2 decades, was being demolished in weeks. He was no longer the man who judged. He was the man who needed to explain himself. Court colleagues began to avoid him. Lawyers who once feared him now looked at him with a mixture of mockery and pity. The narrative was more powerful than the facts. If a career judge was deceived so childishly, how could he judge the lives of others? The process of proving his innocence was an 18-month ordeal. He had to hire international experts in digital forensics and paper chemistry. He had to dive into a world of metadata, cryptography, and cellulose fiber manipulation. He had to learn that truth was no longer in the laws, but in binary codes and electron microscopes. Eventually, the fraud was proven. Those responsible were arrested and the company was dismantled. The judge was exonerated from any guilt. He received his formal apologies and returned to the courthouse. He sat in the same chair, wore the same robe, looked at the same courtroom, but something inside him had died. Now, when he signs a document, his hand trembles for a millisecond. When a lawyer presents impeccable documentary evidence, he doesn't just see the paper, he imagines the layers of manipulation that may be hidden there. He has become a more cautious judge, perhaps even paranoid. He learned the most expensive lesson of his life. The most dangerous trap in the world is not the one you cannot see. It's the one you refuse to believe exists. He trusted the protocols because protocols were made to be safe. He trusted his experience because experience should be his shield. But knowledge doesn't make you invulnerable. Often, it just makes you a more confident target, and therefore easier to hit. The most sophisticated fraud doesn't try to convince you of a lie. It uses your own certainties against you. It uses your trust in the process to blind you. And when you stop questioning what seems obvious, you become the perfect victim. The system didn't fail. The system was used. And that's exactly where the invisible danger lies. The question that remains for you after hearing this story is not how he didn't see what was happening. The real question is, what are you failing to question today just because it seems too official to be wrong? What system do you trust blindly? What documents do you sign believing that bureaucracy will protect you? The invisible trap is not waiting for you to make a gross mistake. It's waiting for you to do everything right. Follow all the manuals, comply with all the rules, because the most effective trap is the one built with the same tools you use to feel safe. The judge is still there. He continues judging, but now he knows a truth that 20 years in court didn't teach him. What is legal is not always what is real. And sometimes the only thing that separates your security from total disaster is overconfidence in what you believe you know deeply. After all, in the game of shadows, the brightest light is precisely the one that creates the most dangerous blind spot.